Hello, welcome. Thank you for joining us. My name is Nicolette Mathey with Atrium 24, and we have Dae Lee joining us as well. Today, we're going to talk about a really exciting topic that's we're all getting questions about from patients, from prescribers in our own pharmacy. Dae's been kind enough to join us today and just have a discussion about what's going on in the marketplace today regarding central fill and GLP combo products. So are these legal risks or are they revenue opportunities? As I said, I'm Nicolette Mathey. I'm a pharmacist and the founder of Atrium 24 and the Dae CRM software. We work with pharmacies. I own a pharmacy, and there's always a lot going on. And you guys know Dae.
Hello, everyone. Thanks for having me today.
So we have a lot to talk about.
Right. We do have a lot to talk about. A lot of up in the air, but I think there are positive developments, whether it be in the legal side, but on the operational side and the industry side. So, I'm happy to discuss that with the folks who are attending today's webinar.
Yeah. So we'll just dive in. This is kind of an overview of what we're going to talk about today, but it's going to be very conversational. Dae and I are just going to chat. I know Dae's a pharmacist as well, and it's important that this is not, legal advice or legal guidance that you can rely on and bring back to your state board or anything like that. We just want to have a conversation, and we welcome Q&A at the end. So during the GLP shortage, there was a lot of pharmacies that partnered with 503Bs. They saw a lot of revenue opportunity. Their patients loved being able to get those products from their local pharmacy instead of maybe an online outfit. Now the shortage has ended, so where does that leave pharmacies?
Yeah, so before we begin, again, I want to emphasize what Nicolette just said about this being not legal advice. I mean, I'm a pharmacist attorney, but also, I'm a pharmacist, but also an attorney. So I wear my attorney hat all the time. I just wanted to reiterate and reemphasize that this is educational purposes only, not a legal advice, not legal opinion. You should seek legal counsel if you need any clarification. Okay, and so we're going to have a lot of discussion, just some of my personal opinion on the developments in the industry. So where are we at right now? Right now is a lot of things are up in the air, as I said before. 503A compounding pharmacies, they can compound products, including that have tirzepatide, semaglutide, but on with a very narrow scope, okay, with exceptions, such as 10% change in dosing, adding another ingredient, or different route of administration. But all these need to be personalized, right? And that personalized prescription must come from licensed practitioners, and it should have, a medical necessity added to it. Okay, so 503As can still continue to compound those products on their own. Okay, there are certain boards that are enforcing the medical necessity, as well as the essentially a copy of restriction. For example, one of the state is the Ohio Board of Pharmacy, that has been enforcing the essentially a copy restriction on their licensees. Okay, so what I've seen thus far in that state is that the board really takes the position, again, my personal opinion, that the each pharmacy who is compounding tirzepatide or semaglutide, they need to show that this is really tailored prescription for a specific individual, and that prescription is definitely was medically necessary for that patient only. Okay, so if you're a pharmacy who compounds with additional ingredient at a and you use that formula for each and every single patient that the pharmacy has, the board will take the position that that it does not satisfy that the product is not essentially a copy of the commercially available product. And on the flip side, 503Bs, 503Bs, the shortage ended, right? Tirzepatide and semaglutide are off of the shortage list. And from the point of FDA, if you make a 503B outsourcing facilities can only compound products that are either on the shortage list or on the bulk compounding list. And tirzepatide and semaglutide are off of those lists. But in reality, there are 503B facilities that are still compounding these products, right? Or added another ingredient or making changes to the products. And there are 503B outsourcing facilities that actually are challenging the patents on the GLP-1 products.
Yeah, it's really interesting to watch, and it is early in all of this as far as the combo products are concerned. B to A has been going on for a couple years now, and that's become a little more common practice. But this combo GLP is something that's very early, and it's a great point that Ohio is one of the few boards that has come out and made a statement and said that that they don't like, paraphrasing, but that they don't like combo GLPs. It's just interesting because when I try to think about the landscape and what's going on, and what I'm hearing as a pharmacist in the industry practicing. So I'm hearing that there's a handful of 503Bs that are starting to make the combo products. Many are not being very loud about it. Also, there's one 503B, BPI, that started making the tirzepatide with the B6. They're very big. They're very loud. To your point, BPI filed a lawsuit against Lilly to challenge their patent. So from what I understand, that could take a long time, a year and a half. So this is certainly combo GLPs, dispensing them in your 503A pharmacy is certainly not without risk, and it's certainly not just a completely carved out path in the state boards and with the FDA and everything like that. And then medical necessity wise, I know that there were some cases that I was watching as well, where it's starting to be challenged. Think about this from a pharmacist perspective, right? One of the main side effects of these GLPs is nausea for patients, is, they're experiencing a lack of energy, they're experiencing muscle wasting. So if you were to compound, if you were to get medical necessity from your prescribers that the patient's experiencing these side effects, that's why, they need this custom compounded dose, and you were to dispense that to those patients, you have your medical necessity. I don't know if, just as a pharmacist, if I buy into the argument that, that's not customized compounding because you did a lot of them. Because there's so many patients, millions of patients on GLPs, and a large subset of them are experiencing those same side effects. So it would make sense that you would batch those compounds and that you would make a lot of them. So it's kind of like, where is the line drawn from state and from the FDA as far as getting in the way of prescribers being able to prescribe medications, pharmacies being able to dispense them?
Exactly. Compounding has been around for several hundred years. I assume, or at the compounding existed at the time pharmacy, practice of pharmacy started. Okay,
Sure.
And every single patient, there's a pool of patients who are experiencing the same symptoms, right? Lethargic. Then you add NAD, or you need vitamin B12. Whatever the ingredient is, they don't get the same benefit from the commercially available product, or they have some side effects or adverse drug reaction from the brand products, and they switch to compounded products. Okay, so, and there is not just one single patient, or there are multiple patients who are having the same issue. So this is going to test this whole compounding GLP-1s, the combo products. Is going to test the pharmacy's ability to compound, the 503B's ability to compound, and the prescriber's clinical judgment, which FDA has already come out and said they're not going to question it, right? And their prescriptive authority. So And 503Bs and 503As are regulated differently. Okay. 503, so let me just quickly go over the main difference between 503B and 503A. Okay. So in terms of the bulk ingredients, okay, 503B cannot use bulk ingredients unless they're on the drug shortage list or is on the bulk ingredient list. Okay. For 503A, it's a different story. They could use the ingredients as long as they appear on the list approved by the FDA or is from the FDA registered supplier and has a valid certificate of analysis, or they're components of an FDA approved drug. Okay. And 503B in terms of regulation, they're governed by CGMP. 503A, no, they're not governed by CGMP. And for the the enforcement bodies or regulating bodies, 503Bs are governed by or regulated by FDA. On the other side, for the 503As, they're regulated by mostly by the Board of Pharmacy and FDA. So those are the main differences in terms of the regulation between 503B and 503A. And I think it's important for all of us to understand that. Okay. And also, so I think it's important to talk about the regulations before these products or these ingredients were removed from the shortage list. Okay. And 503Bs at that time, and still do, in practice, selling to 503As. Okay. But back then, 503Bs were allowed to sell compounded products, whether it be essentially a copy of it or not, to 503As. Okay. And 503Bs could have also sold to hospital, inpatient, outpatient hospital, pharmacies, retail pharmacy, long-term care pharmacy, physician offices, all those. Okay. And the licenses why 503Bs, they need to have license in the state where they're shipping into. Okay. And they not only 503Bs have to comply with the federal regulation, and they also have to or had to comply with the state regulation. The state where they're shipping the products into. Okay. And it's for now, it's a bit of a, like I said, things are a little bit up in the air. Okay. And you have to make as a pharmacy owner, you have to make a sound business decision, right? And also your ability to continue servicing your patients. Okay. And this opportunity, or 503B outsourcing facility opportunity, it could be a sound business opportunity for a lot of pharmacy owners. However, at the same time, given the regulation, I think it's very important for pharmacy owners to understand the potential risk. And that's
Right.
it's very important.
Yeah, and it's early. Like
Very early.
we're saying, I know I'm seeing a lot of lawsuits come out. I'm reading through them. I'm putting them into AI to tell it, I'm just a pharmacist. Tell me what this means, because I'm certainly not an attorney, and that they're big. Like I think the BPI lawsuit, one of the documents was over 200 pages. So, and I don't understand the complexity of patents and patent law either. But you have a very large 503B that has a very large legal team. They have an 80,000 square foot facility that I visited myself and toured, and with their COO, and looked through all the huge pieces of machinery that they have in production lines. They're from what they say, the largest generic drug manufacturer of epinephrine in this country. So they have their generic drug product lines, FDA approved generic drug products, and they claim that they're running the same process on their 503B products. So it's maybe even a higher standard of CGMP. So, it's not just to like paint the picture of what's going on in the marketplace, what I'm able to observe. It's not a fly-by-night 503B. If it were one of these smaller 503Bs that just started, like I think a couple years ago, there were about 70 licensed 503Bs in the country, and now there's over 90. So it's increased a bit. If it were one of those, it would be interesting. It's just they have a legal, and this is just conversation, but they have a legal strategy. I don't personally know what it is. They did file the lawsuit. It's going to take time. So I just wonder from the 503A pharmacy side, no matter how the FDA is going to regulate 503Bs, no matter how they're going to determine essential copy with additional ingredients, I just wonder on the A side, if you have your medical necessity from your prescribers, if you're doing your due diligence on the 503Bs, if you're documenting, that you're looking at their inspection reports and you're looking at the licensure in your state, even if you're reaching out to your board of pharmacy and asking, what's your stance on these combo GLP products? Is there anything more that a 503A pharmacy could do in their due diligence?
Yeah, I mean, so the board, your board may say that like the one board told me verbatim that if you add another ingredient, totally fine, it's a totally different product. And some boards may not even respond, may not give you any like definitive answer because it's too early, right? The BPI petition to the patent board was filed, I want to say August 4th, right? And it's it's barely a month old petition, and so we don't know what's going to happen. But as you said, BPI is a large company, established 503B outsourcing facility. They have their own legal team, and I'm sure they've done their own legal analysis in terms of viability of their claims versus the legal risk, and they determined that they may have a chance to they have a reasonable basis to challenge Lilly's patent. And so they made a decision to move forward with that. And in terms of 503A, potential liability, I mean, of course, there is a legal risk. And if I were a pharmacy owner, I mean, at that point, I would, determine the degree of the legal risk, what is the financial benefit that I could get from this, and what, plus the patient service side, and make a sound decision that, hey, I'm going to take this risk and run with it, and then continue service patients by purchasing combo products from 503B outsourcing facilities. Or if you think the legal risk is too high compared to the financial benefit, then I would not. So, and in terms of the risk, I want to go back to where 503As and 503Bs worked together before the shortage ended per the FDA. Okay, so back then there was shared liability between the pharmacy purchaser, right, and the dispenser and the 503B outsourcing facility. So you have to, and then at that point, it was all about vetting, right? I mean, 503B in of itself, you have to, 503A had to make sure that 503B is registered with the FDA, and the APIs are from the legit sources, right? And then making sure that there is no disciplinary action against the 503Bs, and also making sure that 503Bs had license to ship the product in the state where the patient is located or the pharmacy is located. Okay, so I always, advise my clients to obtain assurance that, they're not only in terms of the licensing and permit and credentials are established, but also that the product itself, the compound itself, meets specific the specifications that the 503 will handle, so before deciding purchase of products from the 503B. And like, again, you have to make sure that the credentials are clean in terms of 503B credentials. You have to make sure the product is, meeting all the criteria.
Yeah. And I think keeping that documentation, we always encourage pharmacies to print it out and keep it in a binder, that way in case your state inspector walks in, see the product, they're like, you're buying from this, 503B, how do you vet them? And let's say you're not there as the owner and you did all the vetting, you want your staff to know, here's all the documentation, we printed it out, we put the date that we accessed the material on what website, kind of like you're back in school again, and you're having to cite when you did this research, but all those things
Right,
go to protect the pharmacy.
right. I mean, again, it's the 503B's responsibility to ensure that certificate of analysis, formulation, stability, beyond use date are in compliance. But at the same time, from the perspective of 503A, you're buying product from 503B. You should be able to, you should apply the same level of scrutiny on those products and the 503B outsourcing facility.
So there's some questions coming in, for example, the details of the BPI lawsuit and how are they challenging the patent? Have you had a chance to read through it? Just from what I could understand, which is not very deep, but they're challenging the patent in that the tirzepatide is not like an original discovery, or it's not like their molecule by itself. It's not very different from what was publicly available or something like that.
Yes, and I did take a look at the petition. I'm not a intellectual property attorney, so I'm not going to comment on how they're challenging it, but it's important that outsourcing facility, 503B outsourcing facility of BPI size is actually challenging the patent.
Yeah.
I don't think they made a haste decision to do so. And I think it's they've done their due diligence and viability due diligence before filing that.
Well, this is a question that I haven't considered on this topic. So any opinion on making sublingual GLP liquid at the pharmacy?
503A sterile compounding pharmacy. Yes, it falls.
So non-sterile sublingual.
Non-sterile sublingual. It falls. So exceptions again, 10% change, different route of administration, right? Different route of administration or adding another ingredient. So it satisfies one of the exceptions.
Would you still want to get a medical necessity documentation on there?
So I would always get detailed notes, medical necessity document from the prescriber, justifying justifying is not a I don't think it's the right word, but let's just use that for the sake of our conversation. Justifying the purpose of that prescription for that specific patient.
Yeah, maybe aversion to needles or something would be common.
Right. Documentation is critical for pharmacies in days, especially not only because of for this specific topic, for other purposes, right? All these compounded products are mostly, if not all, are cash claims. I understand that, but pharmacies have other claims, right, that they're submitting to PBMs, and when it comes to PBMs, documentation is critical. So apply the same level of standard to GLP-1 compounding.
Yeah, that's good advice. And with the lawsuits too, I know I've seen a lot come across, and I'm curious what's happening with them. So for example, I know that there was a lawsuit against a Link pharmacy, I believe, and that was something that's going to be interesting to watch, because that, a lot of the lawsuits that I've seen in the past have to do with marketing. So of course, if pharmacies are using the brand name or doing some sort of trademark infringement, those are kind of easy pickings. If the patient doesn't understand that they're going to get a compounded product or things like that, those are kind of easy. But the lawsuits that have been coming across recently have been a little more involved. So the lawsuit against that Link pharmacy, and I think that one was where we might get to see if that pharmacy has medical necessity documentation and then how that plays out in court.
Right. I remember seeing some numbers thrown out in the complaint, if I'm not mistaken, but that pharmacy was filling like a lot of prescriptions per day, very large scale that you wouldn't see at a regular 503A. And the complaint was filed on August 4th. And according to the docket, the court extended the defendant, Link Pharmacy's time to file an answer or other responsive pleading to October 2029. So Link has not filed an answer or motion to dismiss the,
Interesting.
yeah.
So what happens, just curious, what happens in that instance? Can they continue business as usual while this is going on? They haven't been giving any sort of like cease order.
Correct. There's no injunction issued against Link. But from my point of view, in the event that the plaintiff Novo, prevails on their case, the more prescription that Link fills adds on to the damages that Novo can claim.
Interesting. And there were other cases going on too that involved the telehealth realm. So I believe that like that Moki and I believe they were heard in California. And the online headline version that I'm seeing from all these telehealth and On the Pen and all these kind of like consumer websites, pretty much that the judge said, take it up with the FDA.
Yes, that was very interesting development. This could also, those cases, I don't think there was the hearing on the motion to dismiss was held on August 28th. I'm not sure if the actual order, I don't think I've seen an order coming down the pipe from the court on that motion yet, but that case may likely we should be able to gauge the other cases based on that case, how those cases will pan out.
Yeah, it's definitely interesting to watch. Are there any other legal cases that you're kind of keeping an eye on or interested in right now?
I mean, there are so many that have been filed and that are being filed. But Moki case is definitely the one that I'm following. Link Pharmacy case, is definitely the one that I'm following. I'm also following the case that Lilly filed against Strive Pharmacy in Delaware. So there are a number of cases, and it's very hard to keep up with which cases are being filed, possibly dismissed, being heard.
Yeah, that's another one. Strive, they're very vocal, even at the Capitol, just about patient choice and customized medication therapy and things like that. So it's I feel like there's a lot of points out there that could become the tip of the spear should things go that way.
Right.
But to my knowledge, we haven't seen anything yet other than the shortage ending. That changed for a lot of our 503A pharmacies on the call, but
correct. I have not seen any FDA enforcement. The most recent FDA, any like related issues are, the manufacturers not following the CGMP. I haven't seen that much of an action regarding 503Bs or even 503As. And for the Board of Pharmacy Enforcement, again, there's like a handful, like less than 5 states that are enforcing or so-called flexing their muscle on their, pharmacy licensees. Ohio being one of them, right? The other states, no.
Yeah, I know California is always tough.
Yeah, California is tough. Ohio, and I want to say Massachusetts possibly. I think Massachusetts' position on, this is before shortage ended. If I'm not mistaken. Their view was 503B sale to 503A is wholesale.
Yeah.
So they weren't allowing it. So
yeah. Which I disagree with. Not that I'm anybody, but I think it would be useful too if the state boards had some sort of continuity as far as, how they're viewing FDA issues and how they're enforcing or
Right.
you have NABP, the National Association of Boards of Pharmacy, and I think it would be helpful even to open dialogue and to bring in state pharmacies, especially
Mhm.
independent pharmacies who are working in this 503B to A arena and try to get some consensus.
Right. But I have not seen any such, maybe there were efforts, but I haven't seen it
And
or heard of it.
a lot of the efforts take resources too. The
Correct.
FDA does not necessarily have a lot of resources right now, right? So maybe enforcement could, or lack of enforcement could have something to do with that.
Exactly. FDA is definitely short-staffed. I mean, our firm and myself, we handle a lot of cases involving the Board of Pharmacy, but also the FDA investigations. Um, I mean, this is my personal feeling, and I cannot confirm or not, yes or no on it, but I feel like, at least in certain instances, I could sense that there were staffing shortages or resource shortages at both State Board of Pharmacy, but as well as the FDA level.
Yeah. Yeah. So that can play a major factor too.
Right. And the other thing is compounding has been around, at the pharmacy level. And, it's not like pharmacies come up with their own prescription. They receive these prescriptions from prescribers, doctors who have the ultimate say in the creating or coming up with a specific drug regimen for each patient that he or she treats.
Yeah.
Not only based on their clinical experience and knowledge, but also based on the patient's medical condition.
Mhm.
And, again, I know for a fact that because I've heard, not directly from the patient, but also from other pharmacies that I represent, some patients just cannot tolerate branded versions.
Yeah.
They just can't, and it's a fact. And and this medication, like tirzepatide and semaglutide, it is I view it as life saving for certain patients. Um, not only just the weight loss, but just overall their quality of life just you know uh, skyrocketed. And people when they're when they lose weight, they feel great and their mood changes. And obviously, the other conditions, the associated medical conditions may go away or it gets better, right? The hospitalization rate goes down, mortality rate goes down, or, I think is inevitable, for a patient to seek compounded version. On the other hand, I'm not sure if the branded versions are truly readily available
Right.
because I don't think so. I don't
Yeah.
think it's easy for a pharmacy to buy branded version. Number one, pharmacies lose money on it, because of the low reimbursement rates set by pharmacy benefit managers. You
Yeah.
know, 99% of the time, pharmacies lose money on the branded GLP-1s when they submit claims. Okay. And even if the manufacturers put out, established this direct-to-consumer cash program, it's still expensive, more expensive than the compounded version.
Right. Yeah, there's so much to unpack there. Yeah, even the consumer like Lilly Direct, I want to say, and even Novo, it's like $500 a month for patients, self-pay, which is too
Hmm.
expensive. And I know you can't circumvent a patent due to pricing issues, but these meds do have a lot of side effects, and
Yes.
it does make sense to customize the therapy for patients. And when you think about when I was in school, I had a professor that was like teaching pharmacy law and things like this. And of course, they said the same things, read the statutes. In Florida, it's chapter 465. and just make sure that you understand it and that you're reaching out to the board for clarification when you need to, that you're documenting everything. And at the end of the day, if you're called before the board and they're asking you, why did you do this? And you did it because it was in the best interest of your patient, or you did it because that's what your patient needed, or, and when we talk about adding B6, should we add B6? If you get a prescription to add B6 or NAD or whatever it is, you get a prescription, it has medical necessity written. You can buy it from a 503B source that you can't find any red flags as to why you wouldn't purchase this product from this source. You don't have any guidance from your board elsewhere where you wouldn't do this. And then you're called in front of the board. Well, to me, that's a patent issue. Like you build this because there's a patent from Big Pharma. Like it just kind of, not all the pieces line up.
Right. There's no easy answer to it, but at the end of the day, if we only look at patients, like they really need compounded medication, and some, a lot of them do, and they can't tolerate the branded version. And of course, these manufacturers, they've invested or committed a lot of money to come up with these drugs. Completely understand.
Yeah,
Okay.
and you don't want to discourage drug discovery either.
Right. I completely understand, but at the same time, you can't take away the pharmacies, the ability to compound from the pharmacies. It's been around since the birth of the pharmacy, and you can't take away the or challenge the prescriber's prescriptive authority.
Yeah, because then where does it end?
Exactly. It's never-ending cycle.
What's fascinating too is I know we're actively working on a direct pharma deal to try to get the branded drug into our GPO with some larger wholesale partners. We have BPI and a half a dozen other 503Bs in our GPO. We know that there's a lot of other 503Bs that have products in research and development, and they're just waiting for more federal guidance before releasing the products. It's just interesting to see all these things happening and taking shape. And then that's a good segue, because something else that I've been working really hard on is central fill. So we've been looking at, and someone just asked a question about it, so it's timely. We've been exploring and vetting and talking with a lot of pharmacies in the US that have multiple state licenses, 40 plus state licenses, that are sterile compounding pharmacies that are interested, either they're already doing it or they want to start doing it, a central fill model for not only compounded GLPs, but a lot of different medications. It just makes sense operationally sometimes to utilize a central fill model where you have your originating pharmacy, you enter into a central fill agreement with the dispensing pharmacy, and then when you get a prescription for a certain product that you don't make in-house, you then put that prescription through to the central fill pharmacy, they fill it and they send it back to you, patient specific, and then you can dispense it to your patient. And there's a lot of nuance there. It's a little more complicated than that. But at the end of the day, central fill is generating a lot of buzz. We've already gone through and vetted probably 6 to 8 different central fill pharmacies that we've chosen not to move forward with for various reasons. Maybe operationally they're not ready, or it's too big of a lift on their end to be able to take that on. They're too busy doing telemed, all kinds of things like that. But I will tease that we're pretty close with a central fill option. I'd like to provide a few central fill options for our GPO so that there's no single point of failure should that product line, production line go down for whatever reason. But legally speaking, what are your thoughts and opinions about central fill for pharmacies nowadays?
So the purpose of central fill is, like you said, to find a partner who could decrease your burden on filling that prescription. So originating pharmacy receives the prescription and send it over to the central fill pharmacy, who's going to fill it for you. And then depending on the state law, whether the central fill pharmacy must dispense directly to the patient, or central fill pharmacy kicks it back to the originating pharmacy, and the originating pharmacy dispenses to the patient. Central fill it allows, from my point of view, it allows the originating pharmacy to service more patients, right? And then provide services and, help the patients out. So I like the idea. However, every state has a little bit different central fill law, right? And if we're only talking about cash claims, yeah, central fill, as long as we are compliant at the federal and state level, totally fine from my point of view. However, if we're talking about insurance claims, PBMs don't like that. Every major PBM in their provider manual has some sort of restriction on the central fill. So, and going back to the cost of medication, right? And I have to bring this up. Every brand manufacturer pays rebates, okay, to the PBMs in order for that manufactured product to be in the PBM's formulary. There are only 3 PBMs out there in the country that control 80% of the Americans' prescriptions, okay, insurance prescriptions. And because of these PBMs' vertically integrated model, they became so big. They almost are perfecting their vertical integration model. They have their own rebate aggregators, okay? And because of the amount of rebates that the manufacturer is paying to the PBMs, the drug price goes up. I think that is one of the main reasons. PBMs are driving up the cost of the medication. And when the cost of medication goes up, you think the PBMs, when they receive the rebates, you think the PBMs are going to pass 100% to the plan sponsors? No, I know that for a fact because I've had cases, litigated, settled cases on that.
Yeah.
Okay, so the drug cost goes up. That means everybody's premium goes up, and then out-of-pocket expense goes up.
Yeah.
It's this vicious cycle.
Yeah, it's bad. And I know there's a lot in in the White House about just showing just shining light really with the new administration and even with
Mhm.
like that Marty from the Sesame Telehealth and lot of appointees that have been interesting to watch. And then, you have medication costs being so much lower in other countries and the mandates to bring it down in ours.
And they don't have PBMs in those countries.
Imagine that.
Yeah, they don't have PBMs. And the House committee, they just recently expanded their investigation into rebate aggregators owned by PBMs.
Interesting.
And so just since we're on the topic of PBM and rebate aggregator, just real quick, 3 PBMs in the country that control 80%, CVS Caremark, OptumRx, and Express Script. CVS Caremark has their own rebate aggregator called Zinc. Okay, Zinc is in the US. OptumRx owns a rebate aggregator called Emisar. Emisar is somehow, I don't know why, I could guess why, they're in Ireland, the country Ireland, okay? And Express Script owns a rebate aggregator called Ascent Health. You know where they're at? They're in Switzerland. All negotiating rebates for claims paid in the US, dispensed in the US. And they're getting not only fees, but they're also receiving rebates from the manufacturer for the drugs dispensed in the United States when their headquarters is in Ireland and Switzerland. How bizarre is that?
That's pretty wild. So do you think there's going to be some light shined or some enforcement action on that, or?
Yes, I do hope so. And then another example of, besides the Congress level effort, there are a lot of lawsuits that are being filed by states, right? For example, Ohio is the prime example of the state attorney general who is gung ho on taking down the PBMs. And in fact, one of the most recent complaints that the Ohio attorney general filed against Express Script, Prime Therapeutics, and Ascent and other entities, he is calling them out as, modern day mafia because they are.
Yeah. Well, Ohio was the one that had that like $250+ million Medicaid
Audit, right? Spread from Caremark and OptumRx.
What a mess.
Yep.
I think too, when you make the argument and when pharma makes the argument, like we need to protect our patents, we need to recoup our R&D, and we need to do all these things, and it's complicated, and that's why we do it. When you think about what's happening in modern day and with AI, I've been reading a lot of interesting articles about how AI is actually going to help in the drug discovery process and
Hmm.
help to speed up the time to market for these new treatments. And so you would think that that would decrease the actual cost of R&D if you're able to employ AI, and then maybe the patents wouldn't need to be as long or as costly, and maybe the cost of medications could come down.
Right. But cost of medication, another part is PBMs will need to take less percentages or less money on the rebates.
Yeah, that's too idealistic of a thought process.
Yeah, I mean, I think the industry is moving, is having like upswing, I want to say, from the pharmacy perspective and the plan sponsor perspective. Of course, we're still dealing with low reimbursement rates. Okay. That's just, that's just a fact.
Yeah,
But right now, there are a lot of good things happening. Congress level, federal level, and the state level, even grassroots level, a lot of folks are more educated now.
yeah,
And, if I ask someone, on the street, hey, have you ever heard of a PBM? Have you ever heard of a Caremark? Nobody would knew that term, that name, right? But now it's being, there's a lot of news and media spotlight on the PBMs, and more people are being educated. And there are also lawsuits filed by employees against employers,
yeah.
class action lawsuit, for alleging that the employer failed to properly manage prescription drug benefits, resulting in higher out-of-pocket costs, higher premium.
It's true. It's like that's the good fight that needs to be fought. And in the meantime, I feel like us smaller guys are going to pay our bills with self-pay, health, wellness, and competing with the telemed and the online type market, and just keeping those patients in our pharmacies instead of losing them to online. And I was
Right.
even today, Hims put out their, I think it was like Hims put out their quarter 2 earnings report, and it was like, gosh, $55 million, and they're just from a quarter. And then they have like all their projections, their subscribers are up by 30%, their profits are up by X%. And these markets are growing. I know the number of independent pharmacies is decreasing, but if you look at the market as a whole, patients are taking more prescriptions. Patients who used to buy so much in the supplement market, because that's a huge market,
Hmm.
I believe a lot of those dollars are transitioning over into prescription dollars on the telemed side for things like Samoralin and glutathione and different peptides. You have a lot more peptides that might be coming available soon, like the BPC 157, and
Hmm.
not to get your blood pressure up, talking about all these crazy, but there's a lot that could happen. So for us pharmacies to pay our bills now while we're waiting for all this, um, well, we're waiting for these right things to happen, but the right things that should happen don't always happen, and they certainly don't happen timely enough. I feel like we can capture through 503B, through central fill, we can capture revenue and continue to take care of our patients. We don't want them experiencing polypharmacy either, where they're getting some prescriptions from me and then some from Hims and then some from Willow Health or whoever,
Right.
picking random names. So if we could keep them all in-house and stay out of trouble at the same time, that'd be ideal.
Right. I mean, look, compounding before, several years before GLP-1, like in terms of industry was, um, it just wasn't there because of, maybe it's the aftermath of the New England compounding tragedy.
Yeah.
And now, like since the GLP-1s came into the market, is live now, is getting that it's in the upswing. And I think from if I only speak on the business side of it, there's a lot of opportunities for
Mhm.
compounding pharmacy, just a lot of opportunities. And more people are more patients are receptive to receiving products from compounding pharmacies.
Yeah.
Just they are.
Yeah, they're being marketed to more now directly.
Exactly.
Yeah.
So more people are exposed to that, and it obviously, helps their condition, improves their health.
Yeah.
So pharmacies, especially compounding pharmacies, are, now more than ever are integral part of the patient's, healthcare.
Yep. Yeah. And that reminds me of something too, when we're talking about the markets and we're talking about data. So a lot of my day is focusing on data. We have PMS integrations in our Dae CRM software. I'm looking at data, I'm talking with our developers, I'm cleaning data, I'm helping with observability tools just to make sure it's all clean and flowing, and it never is as you would want it to. And I'm in talks just in general about, how do we get, so for shortage information, you have pharma saying the shortage is over, hey, FDA, the drugs are available. And then to your point, at the pharmacy level, they may not be readily available. So there's all that going on, but there's no data aggregate from compounding and from 503B, from 503A compounding, 503B. There's no aggregate data set to say how big the market actually is.
Right.
It's cash pay. It's not necessarily going through a switch. It's not, anywhere where it can be aggregated. So there's a lot there, and there would be a lot of just a lot of hoops to jump through, a lot to consider, but I see a world in which we could create a data project or a data aggregate, with everyone's consent and permission to just paint the picture of how big is this market of these patients that are seeking these products from non-traditional sources.
Right. I mean, at the end of the day, data is king, right? You need data, and I think you will be able to, your company will be able to hopefully collect all the data and then be a resource for all compounders out there. And it's going to be objective. It's going to show you objective data, not just subjective. Someone saying, oh, there's this much business out there, or this many patients are receiving compounded products.
Right. Yeah. So that would be interesting. We have a question. Someone's asking, this is a good question about, and if you guys have any questions, feel free to pop them in the last few minutes here. But we have a question about central fill liability. So what is the originating pharmacy's liability in the central fill process?
Well, first of all, central fill in and of itself, again, is you have to make sure that you are compliant with state law, right? As well as the federal law. And if we're talking about cash claims, I don't think there's that much of a liability as long as everybody's doing their job, as long as everybody's complying with the regulation law, right?
Yeah.
On the other hand, if we're talking about insurance claims, PBMs don't like that, and that
Right.
is also can become an operational risk. Okay, but central fill is an important, I think, business arrangement that frees up the originating pharmacies ability or time to service all of their patients. It may open up new source of revenue. And central pharmacy too, it opens up additional source of revenue for that pharmacy, because central pharmacy will be paid for doing
Right.
the work.
What if there was an issue with the product itself? What if it had a contaminant or was compounded incorrectly or something like that? And if there was harm?
Yeah, it's both. It's both. The
Like,
originating pharmacy and central fill pharmacy. That's why it's critical to have the clear terms within the central fill agreement. Okay.
yeah.
And same thing for the agreement between 503B and a 503A pharmacy. Okay. It has to be there's got to be a clear term set within the agreement that divvies up who's going to do what. What am I getting from this 503B? What am I getting from originating? What am I getting from the central
Right.
fill pharmacy?
So could you say then, let's say, God forbid, let's say there was patient harm in an improperly compounded product, whether it be from a B to an A or from an A to A in central fill.
Mm-hmm.
Would it kind of be both ways where the patient can sue, both pharmacy entities because they were harmed, and then the pharmacy, the dispensing pharmacy, the the 503A pharmacy that dispensed the prescription to the patient, they should have in their agreement with that central fill or with that 503B pharmacy that, hey, if you compound this wrong, we can come after you.
Possibly, but at the same time, if the originating, there's so many different varying factors, right? Like if the originating dispensed it, maybe there was some shipping error or delivery error, and then if obviously there's going to be the malpractice insurance guys come in, and
Yeah.
there's a lot of variations that may change the result, but the starting point is have a clear, boundaries of obligations and liability in that contract.
And then someone asked earlier, did you mention a limitation in Ohio for 503B to 503A pharmacy dispensing?
No, I believe I mentioned Massachusetts, their viewpoint on 503B wholesale to 503A.
And then someone asked, they may have missed this. Well, we kind of didn't answer it directly, and we kind of can't, but they said, how can a 503B use tirzepatide to compound if it isn't on the shortage list? And so that's the $1 million question.
Right, and I don't represent the 503Bs that are compounding right now, so I can't comment on it. But again, if reputable 503B or reputable company decided to compound tirzepatide or semaglutide, I presume that company and their legal team conducted due diligence analysis before making a decision to compound those products.
Yeah. Yeah, and I mean, when you look at it, they wouldn't be quick to share their entire legal research and strategy and thing that they have, because
Right.
then they're pretty much giving their playbook to the entire market of their potential competitors in the 503B space, and they're not required. They're not required to make that information public. So
Correct.
it's interesting to consider.
And the other thing is, like, would it be a great business opportunity to continue compounding? I'm sure it is, right? But also, it would be a great opportunity to change people's lives, have a real impact on their lives.
Yeah. Yeah.
I mean, it has, like, it's people not only lost weight, but improved overall health and their lives in its entirety.
Yeah. Quality of life, life expectancy, comorbidities.
Yeah, like not just physical, but mental health too.
Yeah. Yeah. Mental health too. That's a big point too. So I'll pull up the PowerPoint again. Have to do a plug of Atrium X. We are hot and heavy in the planning of it. So I hope to see you guys there March 5th through 7th in Orlando. It was such an interesting collaborative day. You were there.
Yes.
Experience. And we hope everybody joins us again this coming March. It feels far away, but it's not. And then here's some contact information. So if you're deciding whether to bring this product into your pharmacy, a combo GLP product, or if you have questions about central fill or whatever it is, I highly recommend that you contact Dae and reach out to him, and he can look at your state, look at your pharmacy's just specifics, and give you some non-public webinar guidance on that. And then there's our contact information. Of course, we have the Dottie CRM, we have the Atrium 24 GPO, and we have the Atrium X conference. So if anything we talked about, you guys want to talk about deeper, or if you want to see anything that we have, the data, the resources, we'd be happy to walk you through it individually. So thank you so much for joining us, Dae. It's always great talking with you, and never a shortage of things to talk about, that's for sure.
Thank you. Appreciate it.
All right. Thank you all. Have a great day.